Welcome back. In an historic decision, the U.S. Supreme Court effectively ended race-conscious admission programs at colleges and universities across the country. What could the decision mean for the corporate world and the focus on workplace diversity and inclusion efforts? Joining us to discuss this is Kenji Yoshino. He's the Chief Justice Earl Warren Professor of Constitutional Law at NYU School of Law and the Faculty Director of the Meltzer Center for Diversity, Inclusion, and Belonging. Welcome to our program today. So how does this court decision have implications beyond college campuses?
So it's wonderful to be here, Karen. So I'll begin by saying that as a formal matter, it doesn't, right? This case was under the Equal Protection Clause and Title VI of the Civil Rights Act. And so it doesn't really ripple over into the employment relationship, which is governed by a different set of laws. That said, the reasoning that the court embraced, which was that, our nation is a nation that believes in colorblindness, has clear implications, so that in some future case, if the court were to rule that Title VII, which does regulate the employment relationship, also has to be interpreted in this colorblind way, that means that affirmative action programs that employers have adopted or diversity, equity, inclusion initiatives, or some portion of those could be at risk as well.
So there's some suggestion that some corporations that don't want to get into litigation might be backing away from some of this. Are there diversity efforts that corporations can continue to do that won't be affected by current or future legal challenges?
Yes, I'll begin by saying, Karen, that the litigation risks are on both sides of the ledger there, right? So if employers back off from the diversity, equity, inclusion efforts in reaction to this most recent Supreme Court case, they will actually be vulnerable potentially for first-generation discrimination suits, right? That say that their policies have unconscious bias sort of loaded into them and therefore have a disparate impact on racial minorities or other protected groups. So I just want to note for your listeners that the litigation risks are very much on both sides of the equation here.
It is disturbing. Go ahead, I'm sorry, continue.
Oh, no, I was just going to say, and that said, even under the most kind of dark, vision of what could happen here from a DEI perspective, which is to say, let's say the Supreme Court in some future case does embrace this colorblind vision of Title VII and says, having, enrichment programs or belonging programs for racial minorities is just as bad as, Jim Crow or excluding them from, employment. If they were going to say that, even then, there are lots of diversity, equity, and inclusion programs that would still be legal. So just to take some examples, like debiasing programs that say, we worry about, stereotypical language being used in our job advertisements, so we're going to get rid of that. Would be totally fine. Ambient sort of cultural forms of belonging, like having an affinity group, in my view, would be completely fine. And then universal projects, like let's create more psychological safety or allyship in the workplace, would also be completely fine. So I think that this, it's in the political interest of those who have always opposed diversity and inclusion to have this kind of sky is falling meme around the Supreme Court decision. But the reality is that so many things that travel under diversity, equity, and inclusion will be absolutely fine, even under that worst case scenario that I just described.
But we're noticing a very disturbing trend. It's been widely reported that there have been some high-level exits of Black women from the DE&I space, including Janelle English, Executive VP of Impact and Inclusion at the Academy of Motion Picture Arts and Sciences, Netflix's Verna Myers, who was the company's first head of inclusion and a Bostonian, by the way, Disney's Chief Diversity Officer, Latondra Newton. That's just in the Hollywood genre. And according to data gathered by Revelio Labs, DEI professionals are getting laid off at a higher rate than other high-level job categories. Over 300 DEI professionals departed these companies in just the last 6 months. What factors are triggering this trend?
Yeah, it's a really good question. So I think part of what's going on is not just the legal landscape, because the departures, as you noted, sort of predate the Supreme Court case. Although I suppose we could say we could see this coming down the pike, given that the justices had shown their cards pretty early, including in the oral arguments, but also in prior precedent. But I would say that there are economic factors here as well, right? Which is to say that in the wake of the murder of George Floyd, we saw a massive spike in the personnel of the diversity, equity, and inclusion industry. And I think in the wake of that, there's been some tapering off of interest and commitment, such that when economic downturns or recessions happen, the people who are the first to be let go are the individuals who hold these positions. So I would say that's a combination of both economic and legal factors. But against all of that, I will say that many of these institutions have people who deeply, deeply care about diversity, equity, and inclusion, whether or not they bear that title or not. And so in some sense, I think that both of these economic and legal forces are kind of like the irresistible force meeting the immovable object. I think we have changed as a nation. We're much more diverse. We're much more aware of our own diversity. And therefore, as Justice Sotomayor said in her dissent in the affirmative action cases, I think diversity will live on just because it is housed in many institutions as one of our core American values.
Now, many of the country's chief diversity officers are going to be gathering for a conference in August on Martha's Vineyard, and you're going to be presenting at the conference. Why is it important in times like this for chief diversity officers to come together?
Yeah, well, it's incredibly important because they are carrying so much of the pain and angst, of these jobs, and it's really important for them to be with each other because the only person who really understands, and I say this as somebody who's not a chief diversity officer himself, the only person who can really understand what's going on in their lives are their peers who sit in the same roles and have to deal with the same thing day in and day out. These are some of the most kind of impressive and heroic people, that I've come into contact with, and I'm really privileged to be with them. I hope that, in speaking with them about these legal cases, I will be able to offer them some comfort along the lines of what I've just offered here. Obviously, we'll go much more into depth into the nitty-gritty of the legal landscape. But I think that both the comment, Karen, that we're seeing a lot of like diversity and inclusion is dead because of the Supreme Court case, but also at the other extreme, nothing to see here. This didn't really touch on the employment relationship, and so this is not going to impact our work at all, are wrong. And part of the project of the summit, right, and my work there in particular is trying to thread the needle to help individuals preserve their fundamental commitments and their fundamental programs, but do it in a kind of way that's weatherproofed against legal challenge.
All right, Kenji Yoshino, thank you for joining us. And just a reminder, the second annual Chief Diversity Officer Summit takes place from August 9th to 11th on Martha's Vineyard. The theme, the evolving CDO, from affirmative action to belonging.